Welcome to Due Diligence after DeMar versus Commissioner of Internal Revenue Service. This Tax Practice Pro webinar was previously recorded on August 29th, 2019. No continuing education credit is available for this rebroadcast. Good afternoon and welcome to DeMar versus Commissioner Tax Practice Pro's free webinar for the week of August 29th. My name is John Sheeley. I'm on with my good friend, Kathy Morgan. Say hi, Kathy.
Hi, Kathy.
Kathy is coming to you from someplace in Louisiana where there is not yet a hurricane.
Yeah.
All right. So, and this is the first webinar I've ever done with Kathy. I've spoken with Kathy, never done a webinar with Kathy. All right. So, a couple of housekeeping items. Those of you that are here live, you'll earn 1 IRS continuing education credit, 1 NASBA CPE, or 1 CTEC credit. To do that, I need you on for a total of 50 minutes out of the hour or so that we'll be chatting back and forth. I also need you to ask the polling questions. I believe you that you're going to be here and paying attention, but the regulators don't. So I will ask you 4 questions. I need you to answer 75% of them. So answer 3 of those questions, and I'm happy to issue you the credit. It takes us about 10 days. There's 400 of you almost registered, I think 360 something registered for the event. It'll take us a couple of days to go through it, but as soon as we go through the list, we'll post the credits. Give me 10 days. You'll get a certificate in the in your email. Paper certificates come from Simple Cert. You'll see the email. You'll be able to, it'll come to the email where you registered for this class. You can see all certificates for courses you took with us since January 1st, 2018 will be in that locker. If you don't get that in a few days, by all means, check your spam. If you still don't have it, please email me, john@taxpracticepro. Very happy to try and help you resolve it. If anyone is renewing, I know that this is the end of the month. If anyone has a license renewal this month and you need the certificate sooner, call or email me, and I'm happy to try and get you through that as soon as you can. So I'm always looking for something interesting to do. Handouts. There are 5 handouts. If you go to the control panel, you'll see the handouts. There's 5 PDF files. The most important one is this one called August 29th Agenda, and that just tells you what we're going to talk about today or what we intend to talk about. Of course, I tend to talk too much, so it'll be interesting if we do or don't talk to all of that stuff. But it's got the course name, course description, learning objectives, all those things you need. So Kathy has been a tax professional for, is this 26 years?
Actually, almost 30.
30, okay.
I did 3 years in VITA in the military before I started working for Block.
Gotcha, okay. And Kathy recently retired from H&R Block at the end of last tax season. This is her first year not with Block in a long time. Kathy is both an enrolled agent and admitted to practice before the United States Tax Court, 2 very laudable things to have achieved. So, Kathy, when I saw this article, I thought, who better than to talk about this with me than you? So I get Bloomberg sends me my research service sends me an email every day, and they have a lot of interesting things in it, especially tax court stuff that seems to impact our office. And due diligence has always been a concern of everybody. So first, let me ask you, what is due diligence with respect to child-related deductions, credits, head of household? What do we have? What's our concern as practitioners?
Documentation. Document, and ask more questions.
You mean like the help field in my software documentation?
Yeah,
No.
and everything goes on, just like when I was in the military. If it's not in writing, it didn't happen.
Okay, so first, the old days, what did we do? The old days, I don't know, when we were doing returns 20 years ago, what was our concern about whether we could claim someone as a dependent or not? When, as a practitioner, what was the inquiry?
You got any kids?
Yep, and you got the social security number.
Yeah, you got. Hang on a minute. Let me dig that out. Let me pull that out because I'm not quite sure how to spell their first name
or which last name they have. Yeah.
Yeah, exactly.
So then we start to evolve,
And then they say, I paid perfectly good money for that kid, so I could
Well,
use it on
we
my tax return.
we started. There were no penalties. 20 years ago, there were no penalties on the practitioner or the taxpayer.
Right.
So then we see the
Except they lost their refund, but
they
you know,
lost the refund that they probably weren't entitled to, or right. So then, God, I still owned block offices. So 1999, 2000, maybe the 98 Tax Act. Somewhere in there, we introduced the concept of the 2 and 10-year penalties. If I fraudulently claimed an earned income credit, I as a taxpayer could lose the ability to take the credit in the subsequent year.
yeah, I think that was in the 98
Okay,
act, and it became effective in, they gave them a bonus year, so it didn't kick in until the 20 tax year,
got it. So
or
I
2000 tax work.
2000
Yeah,
tax.
yeah.
I only remember that because I owned block offices still, and I sold them in 2003. So that was a shocker as we started seeing people then 2, 3 years later, the return would reject. Why? With a code that said you can't take the earned income credit this year.
And then you had to do the 8862.
Right.
They did. I don't think they actually put an 8862 in there, so you could say, but no, wait, this is a different child. We're going to talk about that later,
Yeah.
because there are some new changes involving that as well that just hit the books like 2 weeks ago.
So our next step was, and feel free to correct me if I'm off the kilter here. A couple of years ago, they said, you know something, you tax pro, we're the government and we're losing this battle. We'd like you to do more work for us. And if you don't, we're going to penalize you.
Right. IRS's police force, here we are.
Well, or making us do a better job of interpreting the law, right? So
Right.
all of a sudden, what happened a few years ago? We had to start asking some uncomfortable questions and things of people. What was due
Right.
diligence now? I'm going
Oh,
to click.
yeah. Yeah, due diligence is and love when changes like that happen in a year when there's a big tax change like last year, TCJA. I threw a whole bunch of stuff that we really should have been doing already under the bus wheels of, there was that big tax change last year.
Right. So the first level of this a few years ago is we had to start asking for what from people?
Proof of the residency, proof of relationship, proof of custody if we're talking kids, which we are.
Right.
We had to have all of that stuff documented. And mainly I just did it in the first year, documented it, and then in prior years, prior knowledge documented in whatever tax year it was, I documented.
And we had to stick it in the file,
Yeah,
right? Stick the
exactly.
documents, see the social security card, see the birth certificate, and actually read it.
Right,
Right.
right.
And then what was, so if we were audited and didn't have that, what was the penalty?
The first year, I want to say it was $500
Yep.
for, but that was for the due diligence side, the 8867.
Yep.
And for a lot of years, the 8867 was not a you gotta send it in thing.
Correct. You had to have
And
it in your file.
Absolutely. And the backup documentation, if you didn't have any, or the due diligence stuff. And I always tell everybody, due diligence, to the way to avoid a due diligence penalty from the taxpayer's pro side is consistency. You
Yep.
do everybody's due diligence the same way. My kids brought me birth certificates and social security numbers for the grandbabies. Not that I wasn't in the room when each of them were born,
Well,
but
you
my
know,
kids brought those and they went in their files. And you do that for everybody. You document everything.
prior to this year, I was not eligible for the child tax credit.
Hmm.
So this year, Tax Cut and Job Act. Thank you very much. $400,000 or less AGI. I had a bad
Yes.
year. I did squeak under that $400,000 limit, and I got the child tax credit. I have in my file my own documentation because
Right.
I am concerned I would be held to a higher standard. Plus, it's really convenient whenever I need it. I've got it scanned in here.
Yeah, exactly. Especially with that baby fixing to go to college before too much longer.
Don't she got a
Don't
driver's
I know,
license.
don't start, don't start.
She drives my car too. I didn't buy her a car yet. I do need to throw up. Let me throw up an attendance poll while we're here, because I think we've got a whole bunch of people have jumped in. I'm going to wonder how did you learn about today's event? If you wouldn't mind sharing with me. And again, remember, I need you to answer, please, 3 of the 4 polls.
This is a popularity poll, by the way, because if you choose me more than John, then he gets mad, but that's okay.
I'm going to get mad about something anyway because I'm a big old baby. About 18 of you have not voted yet. If you could vote, and we'll move on. Please. So someone asked if this will count for ethics, and I don't do ethics. And I'll tell you why. We probably could have spun this as an ethics class, but Kathy, did you know enrolled agents, as you know, have to get 2 ethics CEs every year?
Hmm.
Did you know that if you get more than 2, they're a wasted credit?
Right, they don't roll like Update does.
You can't count them for anything else. So many places do 2 ethics. You go out and spend $500 or $600 for a 2-day program. They throw the ethics in. I think everybody's getting ethics so many places, and now NATP gives you 2 free classes or 1 free class for
If
everybody.
you're a member, you can take the 2 free ethics courses from the webinar because they're not going to be in the 1040 series this year.
Oh, they're not. That's
No,
interesting too.
we took them out last year so we had more time for TCJA.
Got it.
And
Oh,
then
interesting.
that worked so well that they decided that since they changed the membership stuff, that they had the ability to take ethics online for free as well. I mean,
Okay.
they can take any 2-hour class, but if they wanted ethics, they could take ethics.
This is interesting. Kathy, do you have your oh, that's the audience view is showing that can you guys see us? Just somebody chime in. Yes, okay. Now, Nancy Cook, Nancy, I don't know you. I'm gonna pick on you though, because you made a very nice comment here. So, Nancy works for one of the national chains, and they tell us not to retain copies of anything. We have seen the documents, yes. We have no copies to show proof. What do you do to protect ourselves since the company tells us not to copy anything? Well, I have an opinion, but I'll let you go first.
Since I am more recently a member of that organization, uh, I'll tell you what I did. I documented it and scanned them in anyhow. I even told my regional manager at one point that his line in the sand for due diligence may be one thing, but mine is something else. And I'm going to do what I need to do to protect myself because I used to do all the off-season due diligence audits for them for several years.
So when I had block offices, I had 35, 36 preparers. We had a total team of 50 the last few years. And I know mistakes were made. We were not keeping copies of things. We were doing as Block said. Now, the interesting thing there, if I remember correctly, Kathy, Block, if you followed their rules, they paid the preparer penalty if one was assessed.
Yes.
So
But that
I
was
would have,
before they changed the software, and anybody who was with Block during that time frame will notice that one year on the due diligence software, it asked 3 questions and left you no place for remarks. Yes, no, yes. Those were it, and you were done. And then that summer, they audited a boatload of Block offices. We had like 3 in our district. And the company ended up paying all those penalties because the preparer did exactly what Block trained them to do.
and their software didn't comply.
And the very next year, software spread out notes that blah, blah, blah.
Right.
So
And
now
it
if
gives you
you,
a diagnostic to put in a note too. It doesn't let you leave it blank. The other thought I have there too, Nancy, is that, and Kathy, we were going to talk about this later. I'll bring it up now. So if I do make a mistake on return and I get a penalty, 500, now it's $530, I think, or 550, 530 this year. Oh, I I can't hear you. Can you hear me? Can you guys hear Kathy? Is it her or me? Cannot hear Kathy. All right, they all can't hear you, Kathy.
Okay, how's that? Is that better?
That's better.
Okay, I just unplugged my headset and plugged it back in.
Okay, so in addition to the penalty, the $530 penalty on me as a preparer, what other penalty is there if I have an employee who makes the error?
Well, they get a $530 penalty, and you get a $530 penalty.
Yeah.
Failure to supervise.
So yeah, failure to supervise. So wrapping this back up to Nancy's comment, which is a good thing to talk about, is that if you own the business and you make that decision, it's kind of you're in for a penny, in for a pound, right? If there's a problem, not only am I paying your penalty because I'm a good employer, I'm going to get my own penalty I have to pay. So you are entitled, if your software meets the requirements, which basically the 8867, and you have to be able to have all those blank lines to add other documentation. If the software asks the right questions, you don't have to keep documents of things. That's true. I have my own practice. I'd prefer to keep copies of things. For another day, of course, that's yet more data to be breached and stolen.
Oh, absolutely.
From my equipment. So, all right. So back, when we started talking about that, we were talking about what we were seeing in the data collection. Oh, now this is interesting too. Someone in Oklahoma who works for Block is telling us the instructions they have are to keep copies in the client packet.
Yeah, he works in a premium office or a Block advisor's office.
Talking about, okay. Now,
and they have different instructions because they fall under a different set of rules and regulations than a regular Block office does.
Now, here's an interesting comment from Vlad Vegas. Vlad wants to know if we ask for these documents every year. Now, I don't, unless they have a new dependent. What are you doing, Kathy?
I don't on the things that aren't going to change, like their social security card isn't going to change. Their birth certificate isn't going to change, that kind of thing. But for the things that are required to be determined every single year, like residency, they could have moved 6 times since we saw them last year.
Now let me ask you a comment here. So let's say you have a nuclear family for a minute, right? That child's mother and father live together and are married. I ask if the child is still in the house. Right? I don't ask for proof of residency
unless they've moved.
Well, yeah, I mean, if it's the natural parents who have previously documented the residency, who else would they go live with?
Mine live with me.
Well, got it. All right. So, but otherwise, things that don't change, no, Vlad, I don't ask again.
Yeah. And unless they're under 5 or they have no health care coverage of any kind, there are simple ways to get the residency thing. I mean, school records, medical care coverage, those 1095 things are great for more than keeping the penalty away. Because the 1095 B, C, A, whatever, have the kid's name and address on the same 1095 the parent are on. That's my primary means in the last 3 or 4 years of documenting residency.
And in examination of the preparer, that holds up?
Yeah.
Yeah. Good. Yeah. Okay. So 2 other comments in here. One is that if you make copies of IDs, don't make a copy of a military ID.
Oh yeah, I'm real good about that because I got some of those. And I've told people who have wanted my copy of my ID for something. No, you're fine to look at it. Here you go, but you can't make a copy of it. It's against federal regulations.
And one of the individuals, another person who works at a Jackson Hewitt franchise, is saying that they've been instructed to make copies. So,
well, their franchisee is opening themselves up for some serious penalties because it is literally a federal regulation.
No, not the military ID. He's saying
military ID. Okay.
General, just because we were kind of wrapping up that conversation. Okay, so back over to this then. I want to get back on track with what we were talking about with due diligence. So that brings us up to now.
Mhm.
Penalties this year, we said, are $530.
Right.
So I've had this problem. So back in the day, my people, if they had been married, they never had their paperwork, ever.
No.
Especially that 8332, except I think if we gave them a blank 8332 and they came in 5 minutes later, I think they went outside and got it signed, on the hood of the car. But we were allowed to do something different. If I was the non-custodial parent, what could we do back then?
We could use the divorce decree prior to 2009.
Right.
2009 is the year the IRS said, no, not any good. You got to have the 8332.
So 2009 and prior, you put the first page, the last page, and the page that said who the kid lived with, whatever the child-related contingencies were. Yeah.
Correct. And what the IRS did is they said, look, we're not getting into the marriage game, because you could go back to court 3 or 4 times and get that original divorce decree changed.
Yep.
And so they went, we're not doing that. Y'all are both going to sign a piece of paper. And if you can't agree to sign the piece of paper, that's a civil problem between you and your ex. Go get it fixed in court.
Who's going to sign the paper?
The person releasing the exemption, so the custodial client signs.
I thought you said y'all. That's all.
I said y'all.
Y'all. Okay. And that's who?
Okay.
That's more than one person is y'all?
Yeah, it depends upon who you're talking about.
All right. And what's the plural of y'all?
All y'all.
All y'all, right? Sorry. All right. So we have penalties both on our preparers and on us. This is serious stuff. And I have to tell you, one of the things, occasionally folks call us up, they're buying a practice, and they ask, what should I look at? What should I do? And I wrote an article for the NATP Journal a couple of years ago, and I did not put this in there. And if I were to write that article today, I would put that in there today, which is to go back and go back and look at documentation. What's in there, what things were answered, because I got to tell you, I know someone who bought a multi-thousand client practice this year. Don't say who it is if you think you know who it is. And they didn't have one 8332, not one. And it's mind-blowing that, that all the people there were no documentation, just claiming the non-custodial kids.
Right. And the problem with that is that triggers back to us because the IRS finds that out when the other parent claims them, and then there's the tiebreaker rules and all of that. And when the IRS sees a certain percentage of your clients all having the same problem, guess who's on the list for a due diligence audit from the IRS?
Yeah, you.
Mm-hmm.
It's interesting too that oh man, we're encountering them. You know how they're getting around this? They put down that the kid lived in the house, even though they didn't. Put down that 12.
Absolutely. Which is how the main reason they're figuring this out and catching these people is the other parent also claims that the child lived with them for all 12 months. And then we do the tiebreaker thing and all of that. And that's where these people are getting caught and where it's getting tallied up against you've been a bad guy list.
Hey, an interesting observation from people. If you know Carol Pettit, Carol's a retired government employee, an EA, and an attorney. My military officer husband says the regs have changed on copying military ID cards. Copies are now legal. I use a copy, and she's for proofing, for picking up prescriptions and things. So that's interesting too. Learn something new.
Yeah, but that's being used for a military government reason. Because I have the same thing. I carry a copy of my husband's ID card in my wallet with the little card, the military. They do it online now. You don't have to actually carry the little card, but the little card that says this person has permission to pick up my prescriptions.
Got it. So one last thing, in the tax system is unfair. There is well, and sometimes it is fair. So there was one of the famous TurboTax self-preparers,
Mm-hmm.
and I think that I heard this from our friend in Nevada.
Mhm.
There was a woman, a waitress doing returns, no documentation, and got zinged by the IRS like I want to say $50,000 in penalties. This is what somebody Shirley ran into. And why? Because do you know there's no 8867 on non-commercial tax software?
Absolutely, because it's not supposed to be being filed by professionals, and the 8867 is for the paid preparer.
You
It says
are
it right in the title of the form.
So
But there's a self-prepared version of the 8867 coming not too much longer. It was in one of the very recent legislations. It wasn't TCJ, it was, I think it may have been the PATH
taxpayer
Act.
first? Oh,
Maybe the taxpayer first. It's not too long ago in legislation. They just haven't, it's not real high up on the IRS's let's get this working, because they didn't give them a deadline, but
right.
it is in the works.
So I want to just, let me grab a second poll question. So Kathy, we're going to talk about a bunch of tax court cases today. And I just wondering, as a tax court practitioner, if you could remind us for a minute, some of these things say tax court memo, some of them say tax court summary. What's the difference between the two, and why do I care?
Well, because one of them can be used as precedents in other cases, and one of them cannot.
A summary opinion typically has nothing new, nothing new to the body of law, right? So that's generally
Well, it's kind of confusing. The summary opinion is actually it's something that's been legislated before, but that doesn't mean that they can't use it for other stuff. It's just they're not going to have a whole court opinion about it, because they're not going to tie up all 15 judges or a panel of 3 or whichever one it is they're going to use.
write a full opinion.
Or to write a full opinion, correct. So, and then there's an opinion case, which is basically kind of new stuff. You know, they may have judged on 2 or 3 of the things, but in the entirety of the case, it makes a new specific point. So, and then you have the memo, which, and I always got somebody, please correct me if I'm wrong about the order of things, because that's one of the things I never could pound into my brain when I was taking the tax court case. 2 of them can be used for precedents and 1 of them cannot. Usually the one that cannot is going to be an escort case, a small case.
Right.
Right, because those aren't eligible for precedents, because it's going to be something you don't have the higher standard of rules and higher standard of evidence and all of that. And it's heard in front of one judge, that's when they go out on the road, kind of like we do speaking, and go, 180 places and do court calendar calls and that kind of stuff.
So a quick reply from Donna. Summary is not precedent. Tax court memo is a fact-sensitive determination rather than interpretation of law. Opinion cases are precedent and involve interpretation of law.
Okay. So the memos are not precedents, cannot be used as precedents.
Correct.
Is that right? Okay. Like I said, I always get it backwards.
So along comes our friend DeMar, and DeMar upset me a little bit. So take us through what's the facts of DeMar real quick.
DeMar is basically both parents claimed the kid, both parents claimed head of household, both parents claimed EIC, all of this. And DeMar was not the custodial parent. So when the IRS did the let's determine facts, let's send both of you a letter, and they determined that DeMar was not eligible for any of that stuff. He never did an 8332. Okay. The ex-wife claimed the child after DeMar had already filed. And so what they did is DeMar said, no, I'm taking it to court. And the tax court determined that he was not eligible for the child because even though he said the child lived with him, he did not. He was not the custodial parent based on the custodial agreement and expert or witness testimony. The kid was there maybe a couple of days a month. So
their agreement said he could claim the son as a dependent for odd numbered years if he was current on his support and the wife's income was less than $15,000.
Right. And first off, it was not an odd numbered year. It was an even numbered year. And the wife turned around and filed and claimed the child in that year. And then they also said he could not claim the child because he didn't have the 8332. The wife signed an 8332 after the exam had already begun. And there are new rules about that in the last couple of years as well. And the court determined that the IRS was correct, although there's some funky stuff in the decision because he never would have been eligible for head of household to begin with. He never would have been eligible for EIC to begin with because the child didn't live with him for more than 6 months.
Right.
But the court, they didn't address those separately. They just came to the decision that because the 8332 was signed after the exam had begun, that he wasn't eligible for any of it. They never said in the decision, nor in the other one we're going to talk about, Cook, they just said he's not eligible for any of this. They never put in the actual decision that he wouldn't have been eligible for the EIC or the head of household anyhow.
Anyway.
Yeah, but the thing with the 8332 is if you don't do it when it's originally filed, you can go back and get the 8332 signed by the custodial parent after the exam has begun. But if you do that, the custodial parent that claimed the child has to amend her return to drop the child before the date the 8332 is signed.
His or her, but yes.
And she didn't.
Right, correct. Which is an interesting conundrum and I think typical.
Oh, very, very typical. She signed the release, but then didn't amend her return. So she still won that argument, even if she signed the release. Now, if she had amended her return and then signed the 8332, he would have won on the dependency and the child tax credit. He still wouldn't have won on the EIC and the head of household.
EIC, right.
Right.
So, and as a reminder, so if I do a return and I incorrectly make someone head of household, give them an EIC, give them an education credit, and take child tax credit, and I'm wrong, what's the penalty total there?
Because he ended up losing all of it, it would have been EIC, head of household. No, it was before 2018, so head of household wouldn't have been a factor.
Okay.
But EIC, child tax credit, and
Education credit.
if there was an education credit, yeah.
I'm throwing that out there, yeah.
Yeah, so, and I think the year we're talking about, they were all at $500, so $1,500.
Right. But what I'm getting at is that these things stack per credit. It's not, I got that one guy wrong, that one year, that one return. These penalties stack up for each of these credits, and now the head of household status all stand alone. So I have a question, Kathy. I want to confirm that the IRS does not care what a divorce decree says.
That is correct.
That is true.
That changed in 2009 when the new law came in, and the IRS said, we are out of the fighting between divorced spouses or custodial spouses business. Get the 8332 or, you're toast. And if the custodial parent doesn't want to sign the 8332, that's a civil matter between you and the custodial parent, and you need to take that back to civil court to fight that. I've told a lot of people they won't sign the 8332. Okay, then you need to take her to civil court. This is what your refund would have been if you'd had the 8332. This is what it's going to be. That difference is a civil matter between you and her to take to court. The IRS doesn't care.
You know what I typically tell people, Kathy? If there is no 8332 signed relative to a divorce action, or they had an attorney and they were in New York State, you'd go to family court, but you had an attorney involved, If there's
Right.
no 8332, the attorney dropped the ball.
Right, exactly.
They
And
meant
whether that's a divorce or whether that's non-married parents that one has the custodial of and the other doesn't. And I see that so much with, they've been together forever and they've got the kids, and then all of a sudden they split up and there's no 8332 because neither of them ever went to court and got legal custody of the child. They both have legal custody, and it's going to go strictly on facts and circumstances. Whose house did that child's head hit the pillow more often in?
Yeah, correct. And so most divorce, I'm not an attorney, but most divorce agreements, at least that I've seen, do require that the parties sign any documents necessary to complete the spirit of the agreement or whatever. So they should be going back to whoever helped them, whoever they
Right.
paid a fee to get the document signed.
And I tell you what, in 2010, the first tax year that was in place, my son was getting a divorce and they were doing the custody thing, and the judge, our local family court judge, used to be a tax attorney, and he knew about the new 8332 rules. I almost fell off the bench seat in the audience, but I had come to court with my son and was sitting right behind the defendant's table. And when the judge looked at my former daughter-in-law's attorney and said, and there's some new documents that have to be signed, you need to get your client to sign those, and looked at his attorney and said, you need to provide those documents to them. And I leaned over the bench and handed her the filled out 8332. And the judge went, oh, very good. Ma'am, looking at my ex-daughter-in-law, said, you need to sign that. And we walked out of the court with it signed, and I had about 14 other attorneys' business cards in my pocket.
I need about 40 of you to finish the current poll that's up. You must be on Facebook. So there's a question that I think the law changed, because there's a question, Kathy, how can you not have an 8332 on file when they are required to be mailed within 3 days of the act with an 8453? I thought that stopped.
No, if you're electronically filing it and an 8332 is required, then you're supposed to send that. But the required mailing stopped because when we very first started the e-file thing, you couldn't add attachments, and you had to actually have a hard physical copy of the 8332. Never give them the original because that 8332 is gold.
Right.
And mail it with the 8453s to the IRS.
Which we haven't done in a decade, right?
Right, because we're able to upload a scanned copy of it and just do the 8453 in the system, and then attach it in your MEF files.
So I think the answer, though, that I'm going to say to this person, by the way, is that a lot of folks lie that the child does or doesn't live with them. Now, there's a question: how do you define non-custodial? In Colorado, the default is joint custody. I think that the answer to that is that's joint legal custody. We both get to make decisions, but physical custody belongs to one person or the other.
Right. In Louisiana, it's the same way. It's a joint legal custody, but my granddaughter is in the domiciliary custody of one or the other, even though she spends exactly the same amount of time with each of them.
Well,
she literally moves from one house to the other every Monday.
But we look at how many days where they put their pillow down. Really? What do they live in the same school district to make that work?
Yeah, they live about 3 blocks from each other.
Okay, got it. Look at this poll result. 29% don't have an 8332 for everybody on file.
That's actually a much lower percentage than I would have thought.
Well, you have to allow a 25% margin of error for people that don't want to admit it.
Right. Well, that's true too.
Because we're recording. But yeah, that's a big number.
You also have to allow for the fact the people who are on this webinar are more trained than most tax professionals.
I agree.
Go to the Tax 101 Facebook group and post that same poll.
Okay, someone should. I'm not a member, but someone should. Okay, so just to get back on this, you wanted to look at Cook, right?
Yeah, Cook was pretty much the same as DeMar, except in their case,
Mrs. The biological mother marries another individual.
right. So she was filing with the other individual and took the child. And then Cook filed after the ex did.
Right.
And so his return is what triggered the let's fight it out and do facts and circumstances and all of that. So it was not a case of they could take it anyhow. And he's another one that the court case never, other than saying we rule against him, he's not entitled to any of this stuff, never addresses the fact that he wouldn't have been entitled to head of household in EIC anyhow.
Anyway. Also, he's another one. He didn't attach the 8332.
Right. Well, that's because he didn't have one.
Right. I'm just saying.
Yeah, he didn't have one. So, and then, of course, she filed her return with her new husband before Mr. Cook filed. So the only way they could have gotten that 8332 done and gotten it through, because you can't backdate the 8332 if you file your return and you don't have it and they call you and you go and get one. Again, as in, first off, they won't take one that is obviously backdated, because otherwise you would have sent it in the first time if you knew you needed it. And if they're going to take it, it has to be dated after the date that the other parent drops the child, amends the return and drops the child.
Right.
So he lost on both of those, but again, the court didn't go out and say you're not eligible for this and this anyhow, but you don't get this because you don't have the 8832. They just do it all in one big decision, which I found interesting. Just not addressing it. They address it up at the front about he claimed this, and this. And we say IRS says he's not eligible, and we agree with the IRS because of no 8332, but they never address that he wasn't eligible for the EIC or head of household in the first place.
We have a couple of cases like that in the marijuana space, just for fun here, where they're talking about denying something, and in the cost of goods calculation that they list as an exhibit, it shows depreciation and just a bunch of things that don't 179 depreciation, a bunch of things that don't belong in there, and they don't address the fact that it's wrong. Why? They're taking everything away anyway, so it
doesn't matter, right? Exactly.
Right, it doesn't matter.
Yeah, and then we've got and Gesser, I guess is how you say that.
Yeah, Gesser, yeah.
Yeah, which this was really interesting because the parents were never married to begin with. And after they split up, they lived in an apartment. They stayed living in the same apartment, even though they were no longer a couple. And then halfway through the year, one of them moved, but they literally moved to the apartment across the hallway.
Okay.
So, and there was no custody decision. That's where I was talking earlier. Never married, neither of them filed for legal custody, blah, blah, blah. And he got so they ended up, because the petitioner's parents took care of the child on his days if he was at work. So those count as days for him towards his more than half of the year.
Right.
And because they both lived literally across the hallway from each other, the defendant, the ex-girlfriend, who had moved across the hallway, said that on the days he was working and the kid was with his parents, it doesn't count as days for him. So literally her 183 days was more than his.
This is the guy that worked as a custodian for the school district, right?
And also worked at Lowe's.
Right. So the argument here is when's he seeing the kid, right? The kid's at school all day and the father's at work all night. Sorry.
Right. But when the father was at work all night, the kid was staying with his parents, not with the kid's mom. But the kid's mom argued that because the child was technically with the father, even though the father wasn't there, that those counted as days for him, and that gave him more days than her. So that was an interesting, fell in the nobody had legal custody. So it literally went back to, whose house did the child stay at more one than the other? Because if you added up his days, including his parents' days, he was over the 183. If you back his parents' days out of it, then even though she didn't have 183 days for the year, she did have more days than he did.
Hey, a couple of quick comments that folks are coming up with. It used to be that we filed the 8332 just the first year, and we didn't do it every year. Do we need to send it every year now?
Every year the person claims the child, the 8332 right? Has to be attached.
Yeah.
To the non-custodial parent's return signed by the custodial parent.
Agreed.
That's why when I get those 8332s and it's the every other year thing, I get that part filled out for the first year that went in effect, and I also get the the custodial parent to sign that second part that says, and all future odd numbered years or all future even numbered years, and you keep those things because they're gold.
A couple of comments coming in. Do we have to attach it? I'm sorry. Do we have to mail it in or can we attach it? That's an e-fileable form, right? As a PDF.
You can add it. That's where you go on to the 8453 and you tick form 8332 and you upload it and it goes with the meth file. How all that exactly happens is going to be up to your software.
Now, Mariette is reminding us that some parenting agreements are 50-50. In other words, I think she's refuting my statement that someone always has physical custody. But what I'll remind you is 3 years out of 4, it's an odd number of years. I was just going to say,
yeah, the only year that could be an argument is in a leap year, and every other year, unless they literally go at midnight and wake the child up and take them home, you can't have an even number of days when there are only 100 and right. Or 365 days in a year.
So we're approaching 350. I still want to finish our conversations, but I'm gonna pop up the last question. That way anybody, if you answer the 4th question and you've been logged in for 50 minutes, you've earned the CE. We're gonna talk about a couple of more points, I think. But so why do we care, Kathy, about these things? Aside from it's always good to have a refresher, what does DeMar really remind us?
Well, I mean, it's always good to have a refresher, but it reminds us, it doesn't say that specifically in the case, but one of us reading these cases should know or learn from them that, this matters not only to our clients, because if we screw it up, they're going to lose their, whatever credits it is they got, because the IRS or the tax court, if they go that far, isn't going to buy but that's what my tax preparer told me I could do. We don't care. It's wrong. You're losing the credits, and they're going to come after you, and your E&O insurance is not going to like that. But it's also, you've got your little column at the IRS's thing that says, oh, we've got this one that's wrong this year that Kathy prepared, and we've got this one that's wrong. If I do 600 clients a year and they all have at least one of the due diligence things, and I have 10 that end up losing it, chances I get audited are not very well. But if I have 300, chances I will get audited on a due diligence audit are pretty high. And I'm going to tell you from lots of experience, they come in, the due diligence auditors from the IRS literally come in with a quota. I got to get up to at least this much in penalties. and then I leave. Most of the time, we can get most of those penalties reduced in appeals unless you really did screw it up that badly.
Yep.
But you're not going to get a lot of back and forth with the due diligence auditor in your office.
Nope, they're just doing checklists, punch list, boom, boom, boom.
Right. And here's your bill, and thank you very much.
So
and then you got to go through appeals and all of that, which is a big pain.
I want to address a couple of issues that people have that have asked. I have a client where the court papers gave each parent a half day to make the custody even. That sounds insane to me, and it sounds like two attorneys who just weren't thinking this through. You know, I guess where they have a stopwatch and count the minutes.
Yeah, that's what I was saying. Unless you're in a leap year, that's literally not. Regardless, you got to remember that regardless of what the court papers say, the IRS is like, can't happen. They have apps and stuff on the on your app store. As a matter of fact, I make my son use one. That you literally, both parents go in there and they say, "Kids with me today." The other parent signs off on that, either says yes or no, that's right. And once they have both signed off on it, it locks it in a calendar. Wow. Neither of them can change it. And I've given those to clients, and they've actually taken them to court and won that argument.
Wow. We have a comment. I'm not sure I understand. Why can't we use the divorce decree?
Because in 2009, the IRS said, we don't care what the divorce decree says anymore. What the divorce decree says is between you, your ex, and the civil court.
And you brought up the real driver of that earlier. The real driver is what happened subsequent to that initial hearing that generated
Correct.
the document, right?
Correct.
It's not frozen in time, correct?
Right.
So you need the 8332.
Yep.
When we refer to the numbered year as odd or even, are we referring to the tax year or the calendar year? Well, both. If it's the 2019 return, we're referring to the 2019 tax return.
Yeah. Oh, yeah. When you put the dates, the odd years and even years, the IRS is looking at, on this date, this was signed. It's effective for tax year. I think it even says it on the 8332 that it's the tax year. I'm pretty sure it does.
It does.
Tax year 2012 is the first year, and then the second part is, and all future odd numbered years. So they're talking about the 2012 return that we're actually preparing in 2013.
Is the 8332 only needed for paid preparers? No, it's needed for anybody, right?
Any non-custodial parent that is claiming a child has to have the 8332.
Any problem? See, this is where we confuse people, Kathy, right? Because then we confuse them on the basics. Any problems with two parents agreeing to split the kids? Each claims one, no matter how many nights they sleep at each other's residence.
No problem as long as there's no tiebreaker stuff kicking in. Now, I've actually had clients try to do that, and that's where I do even more due diligence. I had one client that she was here where I live, and her husband, who was in the military, they had split up, and I knew they had split up. They were in the same unit as my son, and so I knew them. But they had split up, and he had moved to a unit in Alexandria, which is about 2 hours from us. And she came in the next year for me to do her return, and she went, no, I'm going to claim this one, and John's going to claim the other one. And I went, when did the second one move down to Alexandria with John? Oh, she didn't, but we're each going to claim one, so we can each claim head of household. We can each, and I went, no, that's not how that works. You know, whether they'd ever get caught, probably not. But my response to that is, if you get caught, the return you get caught for is not going to have my name on it.
You know the name of the custody app? There's a bunch of folks that would like to know.
Oh, hang on, I can pull it up real quick. Hang on. I've got it on my son's phone. I don't have it on mine, but it's real easy to find. Let me see. And there's several of them actually. If you go into your app file and can you see that? Can you wait? I'm doing it backwards because
I can
I'm.
see it. Nope, I can see it. It's good.
Yeah, if you just go into your app and search child custody, it'll bring you up 3 or 4 different apps you can use.
So now there's a question. Would you recommend we go back and get signed 8332s for past years? Well, we were going to talk about what to do this year. What do I do now moving forward? So
Right.
I would think if you're aware of a problem, like if I purchased a tax practice after getting a discount for these problems, my first act would be to probably send a letter to people and say, not that my letter would say, I don't have it and I'm supposed to have it. Is there any way you can send me a copy or bring it in when you come into your audit or to your return? Get your
Well,
return
probably
prepared.
an audit at this point, but
Well, my thought would be like, let's say you've got hundreds of these. Do you necessarily want people coming in for their audit or for their tax prep unprepared? That's twice audit. Their tax prep
talk about a
unprepared.
Freudian slip.
Yeah, not bringing in what you need. I think you want to ask people about it and have them bring it in.
Right.
Same thing if none of these, if in the past you become aware nobody has any documentation or never was required to bring it in, I tell people I don't want them coming in 3 or 4 times, get a tax return done. I need this. I know you, you're nice people, you're whatever. We need this paperwork. Please bring it when you come in.
Right.
So to this question, I might go back. I would certainly tell people I needed it for this year. And when they call me and say, well, I don't have it or how does it need to be filled out, I would probably help them fill it out correctly.
Right.
All odd number years, all even years. I would never backdate a document.
No, absolutely not. And at this point, unless you're talking 18 and maybe 17, anybody who hasn't already been audited on it, they're probably safe because they're only going to audit unless the credits and stuff are way more than 20%, which opens that 6-year statute. Anybody within the 3-year statute is going to be pretty safe if they're past the 3 years. I won't say they can't get audited, but the chances of it are pretty slim. But because the only way they would have audited them is if they caught both parents cleaning the same child. And the MEF system has gotten so sophisticated that it picks those up pretty quickly. And the last 2 years since PATH Act started, they are doing some of that matching up front.
Hey, so I want to get one more thing in and then people are dinging us that they have to go. So one last thing. A good question here. What specific documents can be used to establish residency? What specific kind of medical record or school record? And what must the record contain?
It must contain something that, like school records, you would need 2 years of school records because the school records are going to have either January through May or they're going to have August or September through December, and you have to prove more than 6 months. Okay, so you would need like kids for 2019 would need last year's school records and this current year that they just started schools records, because that covers the whole time. And the records would need to have, and what I find with divorced parents a lot is even though the child is mainly staying with one of them, the school records as custodial parents show the other because that gets them into a better school district. It also throws that out as a usable thing. Same thing with medical records. If the child is on the non-custodial parent's medical records and they're not living, together, which they wouldn't be in this case, they really can't use that. But the big thing is it's got to show that it covered a time frame more than half the year, and it's got to have the kid and the custodial parent listed on there as living together. Shot records are good because usually it's going to be the custodial parent's going to take them and get those done. That kind of thing, but it's got to cover those things for residency.
We've had luck with the school district writing a letter that says our records indicate, Susie lives with John at 123 Main Street.
Yeah, and has been at this school for 4 years and has always, you know,
Our
been
records always
withdrawn.
reflected that, or sure. Yep.
Yeah,
Now it's
yeah,
interesting in whatchamacallit's case, and then we're gonna have to wrap this up. In DeMar's case, he submitted the post office change of address card.
right.
And the court said we can't give any weight to it because we don't know who filled it out.
We don't know who filled it out and it doesn't list the kid.
Right.
Yeah, so.
So we've been beating around whether this should become a 2-hour webinar that we put up, and we just never got around to it. So I'm kind of glad we did this, Kathy. So
Mhm.
if you have questions, john@taxpracticepro.com. Kathy, what's your email?
Kath Morgan, KATHMORGANEA
I will be in Baton Rouge for the Louisiana chapter of NATP, September 23rd, 4th, and 5th. I'll be in New Jersey in mid-November. I'll be in Columbia, Missouri. They even have a little airport there that I'm going to fly into. November 13, 14, and 15. Where are you going to be in the next month or so?
everywhere.
Yeah,
No, I'm in you would ask me as soon as I put my phone away. I'm in Wisconsin at the Wisconsin Minnesota SEA conference in the Dells in Wisconsin the last week of September 18th. Or the conference is the 19th and 20th. I'm going to be at something called AmData, which is a southern regional, covers Georgia, Alabama, Mississippi, Louisiana. And that's in Biloxi the 13th and 14th of September. I'm going to be in the New Mexico SEA the first week of October. And then after that, I go to the Massachusetts, Rhode Island NATP conference the 21st of October. And then I go to the NYSEA in Saratoga Springs right after that, 25th and 6th. And then from there, I go to Alaska, to Anchorage for the NATP 1040, which is the 31st of October and 1st of November. And then I go back to New York for the NATP 1040 run. I'll be in Kingston, Latham, and then Parsippany, New Jersey. That's the week of the 11th of November. And then I go from there to Ohio and do Toledo, Cincinnati, Dayton the week of the 18th.
And you're in Albuquerque in October, several people have said.
Yeah, that's the New Mexico one.
Got it.
Yeah, that's the New Mexico one that I'll be in the first week of November, or the second week of November, whenever New Mexico is.
Kathy, thank you so much for being on with me. And
no problem.
Everybody at home, you're going to get a survey in a couple of seconds. Please take care of the survey. And if you have questions, comments, concerns, email me, let me have it. I'm happy to take the heat. Thank you again.
Thanks, everybody.